Who am I? Well, I appreciate Pete saying one of the premier marijuana attorneys in Tampa. I like to think that I'm pretty good at it. But I will never come up here and say that I'm the best attorney, that I'm the attorney that knows the most. I'm learning every day. I'm learning from being here with everybody here. I can tell you I've represented hundreds of people on everything from misdemeanor possession or possession of paraphernalia to drug trafficking. I'm there on the front lines of the current laws and what people, good people, normal people, have to go through when they get caught up in the system. I would tell you this, I don't believe that, well, I am for the ultimate legalization of marijuana. I'm not against the medical marijuana. I think it's sort of a stopgap. I'll be the first one in line to have my medical card, so I'll be able to obtain marijuana legally. But I believe that the ultimate goal needs to be legalization for recreational use. In doing so, and I didn't have this in any sort of program or anything, but a lot of you are probably familiar with the organization NORML, the National Organization for the Reform of Marijuana Laws. If you want to become involved in the marijuana community, if you want to have easy access to information in various states, if you want to know the laws in various states, and if you want to find attorneys in various states that concentrate on marijuana and marijuana laws, www.norml.com is about as good a resource as you can have. I'm also on the legal committee there. I go to their events. I believe in the organization. I think that if you want to become part of the fight and really in it and get a lot of benefits, look up your local NORML chapter. Look up the national chapter, www.norml.com. Become a lifetime member. It's a way to put yourself out there to show that you support it. Tom mentioned earlier, talking about things, the legal, the political atmosphere that you're dealing with. What I'm here to tell you about is the current legal atmosphere. There was a question earlier, how is the medical community supporting this? I had a case where I was attempting to use the medical necessity defense for my client who was a incomplete C4 quadriplegic. Through NORML, through my contacts there, I found doctors that support cannabis use for medical purposes. I called a lot of these doctors that are members of organizations in other states but practice in Florida. Talked to several of them. Yeah, we agree with you 100%. Will they put themselves on the line? Will they come and testify as an expert witness? I haven't found one yet, okay? So that's what you're dealing with in the medical community. And in a lot of communities, you will find that there are not a lot of people willing to put themselves on the line for something that's controversial. For those of you out there that are leaders in your industry, for those out who are in the business community who put yourself on the line for the issue, I thank you. I tend to, if marijuana is legalized, I'll probably lose money, okay? A lot of my business is marijuana-related crimes. I'm all for it. Why? Because I think it's the right thing to do. Now, while things are looking up, while we all think that Amendment 2 is going to pass, the atmosphere in Florida, the current atmosphere of laws in Florida, Florida has some of the most, well, the most severe penalties for marijuana in the country. Now, for 1 ounce of marijuana, if you're caught with 1 ounce of marijuana, we all know that's not that much. Fits in a small bag, okay? The maximum penalty for 1 ounce of marijuana in Florida is 5 years in prison. Okay? 5 years in prison. Now let's compare that with the state of Alaska. 1 ounce, legal, no penalty. Colorado, fine only. California, well, Colorado's not fine anymore. This used to be. California, fine only. Georgia, maximum is just probation. Hawaii, 30 days. Florida, 5 years. Nevada, fine only. Mississippi, the progressive state of Mississippi, fine only. Minnesota, fine only. Massachusetts, fine only. Florida, 5 years. Okay. North Carolina, 120 days. Those are the maximum penalties. I don't want to scare you and say if you don't have a criminal record and you're found and you're stopped and you've got an ounce of weed and it's your first time and you're here in Hillsborough County, which is the place to be if you're caught, Hillsborough County. But you're not going to get 5 years of prison on a first offense. But the fact is, that's the maximum penalty. And I go to a lot of different counties here, okay? I go to Hernando County. I go to Polk County. I go to Pasco County. Even, I have a case right now, even in Wauchula, Florida, in Hardy County, okay? Where my client's looking at 5 years on a suspended sentence from, not when I represent him, I just represent him on his violation of probation for 1 positive marijuana test after already doing probation for 2 years. So I'm fighting that right now. This is the worst state, #1 ranked for overall penalties in the country, okay? The penalties here are harsher than they are under federal law. When you look at Florida's drug statute, and when you look at this is Florida's definitions of drugs under 893.03, okay? This definition section is the schedule of drugs. Print it out. I didn't print them for everybody because it's about 50 pages. But it goes through the schedule of drugs. And you'll see lists, and you'll see every compound of methamphetamine. You'll see mescaline, okay? You'll see cocaine. You'll see heroin and opiates. Under Schedule 1, a substance in Schedule 1 has a high potential for abuse and has no currently accepted medical use and treatment in the United States. And its use under medical supervision does not meet accepted safety standards. So those things that I talked about, methamphetamine, cocaine, heroin, any opiates, are right there in the same category as cannabis, okay? The same category. Schedule 1, no medical use. To those of you here, to those of you that are educated on the subject, it baffles the mind, okay? It's absolutely crazy. But that's sort of what you're dealing with here today. That's what you're dealing with in the state of Florida. That's why when Tom says it's important to get out and vote, these are what your lawmakers have put into place prior to now. Your lawmakers in the state of Florida have made it the strictest place in the country for marijuana laws. Misdemeanor possession of marijuana, and I think there is a exhibit up there. Misdemeanor possession of marijuana, 20 grams or less than 3/4 of an ounce. 1 year in jail is the maximum penalty, okay? Again, does that mean if you get caught with a misdemeanor amount of marijuana that you're going to go to jail? Probably not. You get caught in Polk County, you might. Okay, there's also, Tom or Pete alluded, I think Pete alluded to it earlier. There's also a nice little thing that the legislature put in there where if you're adjudicated guilty of any drug offense, including if you have half a joint in the ashtray of your car, and you're convicted, you're adjudicated guilty, you will lose your driver's license for 2 years. Okay? There are provisions to get a hardship after 6 months, but try not driving in today's society. All right? Try being a business person and not being able to drive because of that. Possession of paraphernalia is a first-degree misdemeanor. Okay? If you have a pipe with some residue in it, they might not even charge you with possession of marijuana. They might just charge you with possession of paraphernalia. First-degree misdemeanor, punishable by up to a year. Now let's get into the very serious ones. Possession with intent to sell. If you have, well, I'm trying to think of the most ridiculous example. I had a case where somebody ended up having a misdemeanor amount but had it in 3 separate bags. They tried to put that as possession with intent to sell simply because it was broken down in bags. Okay? They don't know that people that smoke cannabis, even for medical purposes, might have different strains that do different things and provide different relief for them. They don't know that. They just say 3 bags, and the picture that comes in their head is this person by the school giving it to 4th graders. That's what you're dealing with. That's what the legislators now think. There's all sorts of penalties for sale and delivery within 1,000 feet of a church, sale and delivery within 1,000 feet of a school, sale and delivery within 1,000 feet of a park. Okay, there's not any place you can really be in a community and sell marijuana that isn't within 1,000 feet of one of these things. Okay, want to look up at this. This is to show you also that the legislature sometimes doesn't even know what they're putting in here. There's a law, the trafficking amount, where it says felony 25 to 2,000 pounds or 2,000 plants. 25 or more plants, formerly 300 plants. The trafficking statute now, the lowest trafficking statute, which has a 3-year minimum mandatory sentence. Any grows, all right, any grow house is going to fall under that. Okay, and I'll tell you why. The law says 25 pounds or 300 plants is the minimum to qualify for the lowest trafficking amount, 3 years. Now, again, those two things don't correlate, 25 pounds or 300 plants. Because when they bust a grow operation here, they take everything, all right? They take it out of the dirt, they usually wet it down, then they weigh it, then they stick everything in a box. We're not talking about usable cannabis buds. We're talking about the entire plant. So my last trafficking trial, I had a guy who had somewhere over probably about 88 pounds. But that's not usable marijuana. The usable marijuana they got out of it was well less than 25 pounds. But 88 pounds was only 100 or so plants, okay? So they've got this 25 pounds of marijuana or 300 plants, and they don't coincide. They had no idea what they were doing when they made these numbers, okay? The 300 plants would be far more than 25 pounds, and yet they have it in there as an ore. This is just to show you that the people out there making these laws do not know what they're talking about. They don't know about the product, all right? There are people, your legislature thinks that every piece of the marijuana plant is going to go and be out and sold to somebody, okay? They do not know what they're doing. It's sort of like when marijuana became a Schedule I drug. There's no valid medical basis for it. Now, there are things in Florida, as I say, I painted a pretty grim picture of the current state of the law, okay? I am hopeful that the medical medical marijuana will pass. I will vote for it, and as I said, I will be the first one in line with to get my card. It's not all bad news. Florida does have something called, well, does recognize a medical necessity defense. So that's the good news. At least we've had a court in the state of Florida, a couple of them. There's one down in Broward. In Sarasota, a state attorney's office did the right thing about a year ago on a medical case. But Jenks versus State. Okay, this is a case out of the Panhandle from 1991. I don't think most attorneys, including some very good attorneys, really know about the significance of this. And the reason why, it never gets used. And I'll go into why, and I'll go into it, but it is there. And it's a horrible situation. Kenneth Jenks was a hemophiliac. In 1980, through a drug transfusion, he developed HIV and then AIDS and unknowingly gave it to his wife. These were professional people in their 40s, early 50s. Never been in trouble, never had any contact with the law. Mrs. Jenks went from 150 some odd pounds to about 110 pounds. She couldn't eat. She had been prescribed everything for nausea. She just began whittling around to nothing. Thomas Jenks, while not as severe as her, also began losing a ton of weight. Nothing would help him. They did, thankfully, have a doctor that would say that cannabis sativa was the only thing that was affected for them. And thus, when they were busted with the 2 marijuana plants that they were growing for personal use, you could tell that even the people in the Panhandle were struggling with it. The trial judge just sentenced them to probation and said that they had to do 350 community service hours just taking care of each other. That was the only thing that they could do for their community service. So it's not like the trial court in this case didn't understand the severity and the gravity of the situation. Nonetheless, you become a convicted felon. The appeals court found that in this very limited situation, that the medical necessity defense was a viable option in Florida. Now, I've been practicing law for 15 years, done exclusively criminal defense in this town for about 6, 7 years. I don't think I've ever seen anyone other than myself even try the medical necessity defense. I sort of alluded to it earlier. I had a case where there was a gentleman who was an incomplete C4 quadriplegic. He jumped into a pool in 1979, 1980, hurt his spine. He had limited use of his arms and legs. He could get around with a cane, but he was generally wheelchair bound. As many of you or many people with medical issues can attest to, medical issues that serious, he was prescribed a cocktail of barbiturates and opiates and other strong things. When he was on this medication, he could not function. He sat in his chair and stared at the TV. He started cultivating marijuana. The way he got caught was someone tried to rob his house. He shot the person who tried to rob the house, and the person fled. The police came out. They're concerned about him. They find the robbery suspect. But they also found that he's got a grow operation. So he gets arrested. Again, the police are doing what they were supposed to do under these laws that your legislators have made. And these officers with the Hillsborough County Sheriff's Office were not without compassion. They didn't take him down that night. They let him show up the next day in his own vehicle with his wife, turn himself in. He got a very low bond. again, these were not people that were trying to single out this guy, but nevertheless, he was charged with felony cultivation. He continued to cultivate, and when they came out there to serve a subpoena, he was charged with a second felony cultivation, okay? Now, this is what I was talking about, the question that I heard about how does the medical community feel about this? I took the case pro bono. I'm not saying that because I think I'm a particularly good guy or anything, but the situation, when you saw this guy, it was just, anyone would have done it. Anyone in my position would have done it, okay? He had 2 felony cultivation cases. I started writing to the prosecutor, citing these cases, Jenks versus the state, medical necessity defense, and I had a good set of facts, incomplete C4 quadriplegia. The judge looked at me like I was crazy. The first thing was, and this, by the way, was the most pro-defense judge sitting at the time on the felony bench in Hillsborough County. He said, medical necessity offense, this isn't California. Okay? Well, it's not, Judge, but we've got this case here. Prosecutor looked at me. Again, he was a progressive guy. Hillsborough County is not a bad place to be as a criminal defendant, generally. But he said, I'm not going to drop the case. I was able to use it in order to get him 12 months probation and a withhold of adjudication, so he was not a convicted felon. But he did have to do probation. The good thing is he did have a doctor who prescribed him Marinol, so he could continue using as long as he kept his levels where they were either at or below the last test. And it turns out after 4 months, we were able to get him terminated off probation, and he is now in California growing legally, and he's very successful in that. So it does have a happy ending. But why don't people use this more often in cases? Well, the reason why they don't use it is to ultimately use the medical necessity defense, you would have to go to trial, okay? You'd have to go to trial where if you lose at trial on a 3rd-degree felony, you're subject to 5 years in jail. This guy would have been subject to 10 years in jail based on 2 counts. If you go to trial and you lose, you can rest assured that you're not going to be getting the minimum penalties. Depending on the judge, you won't be getting the maximum penalties. You may not be getting the maximum penalties, but you're going to be doing jail time. So the position as it is currently in Florida, yes, this defense is out here. It's limited. You can use it, but you're going to have to put yourself on the line in order to do so and face potential prison time. I wanted to talk about a couple of other issues that y'all as people in the marijuana industry and people that believe in this need to be aware of and need to keep reading the legislative bills. There is a bill out, well, I don't think it's gotten out of committee, but I'm aware of it because my wife, who practices law with me, is extremely active in DUI cases. 13 states in the United States have a per se DUI law for cannabis. Per se, meaning if any trace of marijuana is in your system, that's per se DUI. This means that, as we all know, marijuana, the psychoactive effects of marijuana, conservatively, are gone after 6 hours. Okay, if you smoke once, most of us know it's going to be well less than that. Okay, but the psychoactive drug in marijuana will last 6 to 8 hours. But certain types of the THC remain in your system for up to 30 days for people that are regular marijuana smokers or have other medical issues. It can be in your system for much longer, even if you haven't smoked. What these 13 states that have per se DUI laws mean is that if you smoked some marijuana 60 days ago and then quit, never did it again, but you were an active smoker beforehand and your metabolism's slow enough that you're not going to have it out of your system in 60 days, then you're guilty of a DUI. Now, thankfully, I don't think, and my wife doesn't think, that this is going to pass in Florida. And also, thankfully, there was a recent case in Arizona where the court struck this down. But be aware of it, okay? Because if any of you drove into Florida for this, or any of you are driving through Georgia, Georgia has a per se DUI law, okay? These are not good things. I brought that up just because that was a recent thing that happened a couple weeks ago. Now, on a general criminal legal practice, one of the main issues, and it applies to people who are charged with marijuana offenses more than you could know, is search and seizure laws. The phantom smell of marijuana shows up in just about every case that I have. Sometimes there is marijuana. A lot of times there's not. But I'll tell you this, and I don't mean this in a insensitive way, because it's obviously awful. If you are an African American person in this county or any of the rural counties here, and you're driving around and the cop doesn't like you, he's going to say that he smells marijuana. He's going to pull you out of your car. He's going to search your vehicle, okay? And it's hard to fight against police officers and the phantom smell of marijuana because the courts generally go in their favor. And they enforce these things in ways that you wouldn't believe, okay? Recently, the United States Supreme Court, and by recently I mean last week, there was a case in California where two Hispanic gentlemen were driving. Now, they did happen to have marijuana with them, okay, but they were driving along. Somebody, an unnamed anonymous source, calls the police and says, a car, and gave a description of the car, just ran me off the road. They didn't leave their name. They didn't leave any other information. They just gave a description of the car and a description of the driver and said that this person had swerved and run them off the road. Now, up until last week, anonymous tips had to be corroborated to provide probable cause to stop somebody. In this case, the California Highway Patrol got behind the car, or found the car that the lady had called in on, got behind it and followed them for 5 miles. There was no mention of marijuana in the call. There was no mention of anything other than the person swerved once and they got run off the road. They followed the car for 5 miles. The driving pattern was normal. In DUI cases, if a cop follows you and the driving pattern is normal, he does not have suspicion, reasonable suspicion or probable cause to pull you over. Well, the United States Supreme Court decided that this uncorroborated, anonymous tip had the indicia of reliability because the person adequately described the car and the driver. Anyway, California Highway Patrol pulls this car over, smell of marijuana, arrested for marijuana-related crimes. I'm still having a hard time wrapping my brain around the case from a legal perspective. It's ridiculous, and if you look at the Supreme Court, the way they decided it, it was a 5-4 vote. The very conservative judges and Kennedy on one side, and the liberal judges, and then Justice Scalia in the dissent. It's a case that you have to be aware of. It's a continued attempt of the legislatures and law enforcement to erode the Fourth Amendment search and seizure. Y'all know that federal laws prohibit marijuana. You know that under the federal laws, marijuana is also a Schedule I drug. As I said, I'm extremely optimistic that these current Florida laws, after medical marijuana is passed, will change and will become more lenient. I'm not telling you these things to scare you, to people in the marijuana community coming out and people that want to be leaders in the community. I applaud you. But regardless of what Florida does, regardless of what y'all are willing to convince your legislatures to do for the benefits of marijuana, until marijuana is legalized on a federal basis, until it is taken off the Schedule I drugs, as business people, you guys are always going to have to look over your shoulder, okay? So that's what you're ultimately fighting against. I appreciate the opportunity to speak today. As I said, I'm not here for any sort of marketing reason. I tend to lose money if everything is legalized, but I will leave cards out and some folders outside if you want them.